on the record, all parties present, we have Esquire reporting here as well.
Do you see anybody in your waiting room?
We do have people on the Zoom, they just haven't turned on the Zoom. Here, no, they have turned on there. You'll see them in a second.
You are in the meeting now.
All right, so I see the names of the people. I don't know if you see their names, but you can see their pictures.
Yes, there's Dr. Schwartz.
All right, and so we're here for the Spencer hearing in the case of the state of Florida versus Jose Soto-Escalera. It's case number 18 CF 2614. And from the defense, any additional evidence for the court to consider in its decision-making process?
Yes, Judge, you'll see on the Zoom we have Shari Schwartz, our mitigation specialist. She, I think, can offer a better insight into the history of Jose's family than his family. I think she may be a better historian of those facts, and we'd like to take some testimony from her on that issue. She has prepared a report, Judge. I only have the one copy, I think. No, we have an extra copy. We can give a copy to the court. I don't know if Ms. Schwartz will be reading it in its entirety or whether we'll just go over it point by point.
Sure. State have a copy as well?
We do now.
We just got it. Thank you.
All right.
So that's what we would call at this time, Judge.
All right, so Ms. Schwartz, if you raise your right hand, I will swear you. Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Burns, you may inquire.
Tell us who you are and what are your qualifications for the work that you do, Ms. Schwartz?
My name is Sherry Schwartz, and I have a PhD in psychology from Florida International University, and I work primarily as a mitigation and specialist sentencing advocacy, but I also do victim advocacy work as well, not on the same case.
And how long have you been so engaged?
Since 2010. I started with the Miami-Dade Public Defender's Office Capital Litigation Unit in January 2010, and then I went out on my own in January of 2014.
Is that when you founded Panther Advocacy and Litigation Sciences?
Correct.
And how long have you been involved in this case?
It's a little, just shy of 2 years.
Where are you coming to us from right now?
I am in West Virginia working, not on vacation, or I would be in court. And
Very
I
good.
apologize for that.
No, that's fine. Do you have the report that you prepared with you?
I do. I just have it off to the side, unless you wanted me to read it, or did you just want to ask me questions? However you want to do it is fine.
I'll just ask you some questions, but I'm going to kind of run through it topic by topic. If you want to refer to
Okay.
it, go ahead. Just let us know if you're doing it.
Okay.
I first want to address the title. It's a biopsychosocial report. What exactly does that mean?
Right. So biopsychosocial considers the biological, or what I do is I investigate biological factors, psychological factors, and social environmental factors that may have impacted a criminal defendant throughout their life.
And where do you derive the information that gets you to form your conclusions and write a report such as you have done?
Mostly it comes from interviews of the defendant, but also family, any family members, any friends, coaches, teachers, anybody that knows the defendant or remembers the defendant from a long time ago, even if they haven't seen them in a long time. These are potential sources of information. Also records, things like jail records, if somebody has served a prison sentence previously, then I would request those sorts of records. So basically, any kind of information, medical records that might yield some information on these biological, psychological, and social environmental factors.
So it's not overstating it to say that you're essentially trying to reconstruct, in this case, Jose's life from start to present moment.
No, I don't think that's an overstatement. But certainly there's a focus on these particular factors that may be relevant to someone's, to why the person is in the situation that they're in today.
But you certainly cast a wide net as far as people that you might seek information from.
Correct.
You, were you able to observe, whether on television or in person here in court, the testimony from Jose's family in the penalty phase?
I was in court, yes.
And those are all persons that you have met and conversed with before, yes?
Yes, we went to Connecticut and spoke with them.
Is there anything that you think is significant that did not come out in their testimony regarding Jose's prior history or family history that you would like the court to consider? And you can refer to your report if you wish.
Okay, I'm not referring to it yet, but I may just look through to make sure I didn't miss anything, because I neglected to mention I'm also a college professor, yet somehow when I'm testifying, I get very nervous, so I apologize. So one of the things with Jose's mom, so if I take it in chronological order, Jose's mom was 14 years old when she met his dad, who was 20, right? And so they were in Bridgeport, Connecticut. This is criminal behavior. It was criminal behavior back then on the part of Jose's dad. Mom winds up pregnant with a son that was not Jose. He had an older brother who only lived a few months. Dad, Concepcion Soto, when she got pregnant, they left the state of Connecticut. They went back to Puerto Rico. Well, not back, because she was always in Connecticut since she was a little girl, but he took her to Puerto Rico where his family was. She had the baby there, but they were in an area of Puerto Rico where there was no major hospital. She's a child herself. She has no car, no access to transportation, hardly any money, and the baby became sick. Dengue fever was an epidemic at that time, and that's what the baby contracted. And depending on who you ask, if you ask Jose's dad, he'll say that the baby was just sick and passed away. But of course, if from mom's side, he wouldn't take her and the baby to the hospital. His family was not very helpful, and the baby died at home in her arms. And by all accounts, she was very, very different after that. So she gives birth when she's 15. This happens when she's still 15. A few years later, she becomes pregnant with Jose. She's still young. She's 17. She gives birth to Jose at 18 and then makes her way back to Bridgeport, Connecticut.
With Jose?
With Jose, yes.
And he was just an infant at that time?
He was an infant, yes. Little less than a year.
And so did Concepcion, the father, return also to Connecticut?
He did at that time.
Did he stick around?
No, a short time after they separated, he was a bus driver in Connecticut. He didn't live very far. To hear him tell it, he had a wonderful relationship with Jose and Jose's younger sister. But the reality from multiple collateral interviews is quite different. It's that he was in town, but he was pretty much absentee. He had abandoned the family. So he was not somebody that the kids or Miss Carmen Escalera could count on.
And Concepcion had indicated to you earlier in the case his willingness to come and be a penalty phase witness. He backed out at the last moment, is that correct?
Yes, and we got two different reports. He told one member of the family that he had contracted COVID. He told another member of the family that he had a stroke.
What about alcohol or drug use in the family when Jose was growing up?
So Carmen, presumably to deal with the trauma of losing Jose's older brother and then having to be a single mom, and they came from meager means. There's no shame in that, but they really didn't have very much. And to deal with her pain, the trauma, whatever was going on with her, she began to drink heavily. And this was noted by her family, her sisters, Jose's cousins that were in court. And so she didn't take care of the kids, Jose and his sister. They were living in the same building. The family all lived in the same building. It was a close-knit family in that regard. But Jose was raised or living in his aunt's homes in the building.
What was the source of income? Who was working what jobs? Do you know?
I don't know everything, and I honestly don't know if Dad paid any kind of support. I don't think that he did. You know, he may have provided something here or there, but I don't think he was on any sort of formal child support order.
Was Jose's family
But-
receiving public assistance?
Well, the housing that they were living in was definitely a housing project. So in that way, yes. But in terms of monthly checks, things like that, I don't know.
There is a part of your report called transgenerational trauma. What does that mean and how does it manifest in this case, please?
Well, so transgenerational trauma is something that the science supports, that it's passed down through the generations. So even though in this particular case, even though Jose was not yet born when his mother was a teenage mom, a very young teenage mom, and gave birth and then had the baby die at home, her trauma would pass down to him. And I'm not a biologist, I'm not that kind of scientist, so I don't want to overstep my area of expertise. But I will say, just from the psychological impacts of that science, it shows that this kind of trauma gets passed down biologically, that it actually has impacts on kids and their brain development, emotional development, and things that are, these would be a biological factor, but also a social environmental factor where, in this case, mom is having self-medicating and things like that.
Now, the testimony that was before the jury was that Jose left Bridgeport, I think around age 15 or 16, to come to Florida. Is that supported by your research?
Yes, about that age. He was very young.
There is a section of your report entitled Jose's Resilience. Tell us about that.
Right. So resilience, there's a whole body of literature on that too. I obviously I'm talking about it from a psychological perspective. Resilience is our ability to manage situations and rebound and, you know, come out on the other side okay. And so in Jose's case, throughout his life, he's had adversity, but he's managed to stay out of trouble as a kid living in an area where people did not stay out of trouble. It was a very dangerous, very high crime. There's government documents on that, as a matter of fact, that I was able to find and read through. And he managed to make his way to Florida, not on his own. He came with a girlfriend's family at that time. And to hear the aunts tell it, this was a good thing for him, because then this way he's now a teenage boy. He's getting out of ground zero for getting into gangs and things that are going on there, things that he had managed to avoid up to that point. And so he comes to Florida, and his life, even though he's young and he doesn't have parents, he's at work. He didn't have his parents here with him, I meant to say, but he has work, and he has always maintained a strong work history, always manual labor positions, because, you know, he didn't have an education, a higher level of education. But Jose is also someone that's very much tries to make the best of situations that are beyond his control.
There is a section in your report, I'll confess I have some trepidation in questioning you about it, but I think it's relevant. um, it acknowledges the victim, in this case, Tanya and Josiah's loved ones, and they are identified as co-victims, correct?
Yes, that's correct.
And you develop a little bit, I don't know, I don't think it's your own work, maybe it is, but I think it's derived from studies. What can you tell us about the psychology of being a co-victim in this circumstance?
Well, it's not my science. You're correct. It's science that I'm citing. But I do have experience working with co-victims, particularly in homicide cases. And so what we know from the science, but also from practical experience, is that the court experience that is supposed to bring us as citizens, the truth and justice and vindication that we seek, right? If we're a victim of such a horrible crime like this. And what we find is that it actually has the opposite impact. The longer that someone is in contact, a co-victim, with the criminal justice system, the worse their mental health outcomes. So the more contact in court with prosecutors, with police officers, various things that happen around this process, and the longer that goes on, the lower the mental health functioning in terms of higher rates of depression, higher rates of anxiety, and a lot of trauma around that as well. So it's a system and a process that really, for lack of a better word, tortures victims, co-victims. I don't think that's the intent of the system, but it is the practical impact.
Right, thank you. Yes. In your work on the case in the past 2 years, you have conversed with and interacted with Jose?
Yes.
There's a section, I think it's toward the end of your report, entitled Empathy for the Victims, Authentic Empathy for the Victims. What can you tell us about that, please?
Early on, Jose, when I first got on the case, Jose had mentioned, just in conversation, getting to know him, getting to know the case, getting to know his relationship with Ms. Wise. And, this is many years after this happened. He had stated something along the lines of, this is not a direct quote because it was many years ago and I don't remember the exact words, but it was something along the lines of him feeling, I asked him to describe Tanya, and he said, she was a nice person, that she didn't deserve this, and, that this was his child. He didn't know that at the time, of course, but finding that out hit him really hard. And that was unprompted. When I'm looking at those things, if I have to ask a defendant how they feel about it, and I do if they don't tell me, but in his case, I didn't really have to ask about that. And we never really talked about it again because we're talking about other things that are relevant to his biopsychosocial. And again, I guess it was a little more, it was before I wrote the report, as I was preparing the report. And, I was checking in on a legal visit because he had been in court. I wanted to, make sure he was okay after the death recommendation. And the first thing he said to me is, no one has asked me how I feel about what happened to Tanya and Josiah. So, these are the kinds of things that indicate genuine empathy. In that moment when he should be thinking about, or not that he should be, but that most people would be thinking about the consequences for themselves, he mentioned Ms. Wise and baby Josiah.
Now, we haven't touched on every single specific item in your report. The judge has it to consider, and I'm sure that he will. The last item in your report is titled an executive summary, so why don't you tie everything together in summary form for us now, if you can.
Sure. Can I just take a look at that so I make sure I don't miss anything?
Yeah, go ahead.
Is that okay? Okay. I promise I won't read it because it's kind of long. But basically, there are a number of biopsychosocial factors that are relevant to Jose and his life existence. And those things are things like adverse childhood experiences, right? He had exposure to parental abandonment, his father leaving, maternal neglect and alcohol abuse in the home, inconsistent caregiving, exposure to trauma. He witnessed himself extreme violence in Bridgeport, including shootings and gang activity, but he also has the intergenerational trauma. Growing up in poverty, I don't think that that's necessarily something that predisposes someone to committing crimes, but we do know that in high poverty areas, there are higher crime rates. And Jose managed to avoid that, which is really notable. The family also dealt with a lot of discrimination and racism in Bridgeport, Connecticut, when Jose was growing up and even when his mom was growing up. So this was kind of the social environment where they were living, but this is also a family who has really strong kinship bonds. And even if they don't see each other every day or talk to each other every day, they do, they show up, even if they were nervous, they weren't able to really articulate everything that they wanted to say, but they are generally very supportive of each other. And I think the authentic empathy is, to me, I don't always see that. I wish I could say that I did, but I don't. And in this case, it was really remarkable, especially the day after the death recommendation when Mr. Soto-Escalera, one of the first things that he said with a lot of emotion was that no one had asked him how he felt about what had happened to Miss Wise and baby Josiah.
Thank you very much, ma'am. That's all I have for you.
Any questions from the state?
No questions.
All right. Thank you, Dr. Schwartz. And
Thank you.
any additional evidence from the defense?
Judge, may we go off the record for a second? I just
Sure.
need to have a brief contact.
Sure.
with the client.
Absolutely.
Thank you,
We'll
Judge.
take a brief recess, allow the defense to speak to their client. Has had time to confer with Mr. Soto-Escalera. Any further evidence from the defense?
Well, Judge, I did have some commentary to make and some argument to make. However,
Right. But outside of argument,
No more. Well, Mr. Soto-Escalera wants to speak, Judge. I do believe.
okay.
My client would like to address.
Okay, he may make a statement either under oath or not under oath at his choosing, allocution or otherwise.
He's allocating.
Okay, you may make a statement, Mr. Soto-Escalera, at this time. Go ahead.
Thank you, sir. What I'm bringing to the courts to address is, I have a conflict of interest. Mr. Thomas Burke. So I was asking for your permission, if possible, if I can get him removed from my case, because I don't trust him.
Mr. Soto-Escalera, trying to think of how to say this in a way that's most understandable. I think there's an expression, we're at the 11th hour. This is probably even beyond that. We're probably at about 11:59 here. We're about to close all of the evidence in your case, which would be submitted to me with the jury's recommendation, whether you should receive the death penalty or life in prison. Counsel has already done his job. They've already completed their work on the case. Really, at this point, all that's left for them to do is argue to me. So I don't believe there's really any purpose in that at this time. even if I were to grant your request, there's nothing left for counsel to do at this time other than to make argument to me, which quite frankly could be persuasive, but given the judge's function and where we are, as I mentioned, 11:59 metaphorically, there's really not much purpose in that. So from counsel, since it does affect counsel, does counsel agree with my observation on that particular point? I'm going to inquire Mr. Soto-Escalera whether he wants to speak about the decision I have to make and give me input in that regard, because he has the right to do that. But that's separate and apart from what's being said now. Does counsel for the defense agree with my observation as far as, if this is a request to discharge counsel, where
Absolutely, Judge, and that.
the horse is out of the barn at 11:59 p.m., I suppose would be the metaphorical.
Correct, and as I explained to my client, I am not qualified to be on the case by myself, because I'm only second share qualified. So Mr. Burns has to remain on the case to the duration.
Right, and just for the record, I haven't heard the arguments yet, but there's been a substantial amount of mitigation put before me, both at the trial and additionally here today, that I have to consider and digest, and does not seem to me that there's any reason for me to discharge counsel at this time. More importantly, before you brought that up, Mr. Soto-Escalera, you do have the right to make a statement at this time, either under oath or otherwise, that I would consider in making my determination in this sentencing proceeding. You understand you have that right to do that. And I was assuming that you were going to do that. I'm not saying whether you should or not. That's between you and your counsel. But I want to make sure that by me dismissing your conflict of interest issue, you don't take that as me dismissing your ability to make such a statement. Do you wish to make such a statement, or do you wish to talk to your counsel about whether you wish to do that at this time?
The only reason why I brought it up, Your Honor, is because something has surfaced with a witness, and it was recorded in audio. This is why I'm requesting that I would have him removed. But if I can't remove him, I would like you to see what I'm speaking about, so you can understand what I'm trying to say, if you have the time, Your Honor.
With regard to that, that would be a decision in this very important context for your attorneys to make, whether to submit that issue to me as far as potential mitigation. And I would, as I'm required to do, I would defer to their professional decision in that regard.
I think enough, Judge. I'm going to lay it all out on the record, okay? I think Mr. Soto-Escalera is hurting his situation. He's proceeding in ignorance on the advice of ignorant people. What he is referring to is a Zoom recorded deposition, the first such deposition I ever did in my life. We had witnessed Lucinda Cook. This was done, I think, on a Tuesday when there was a court holiday, when we were in the midst of trial or jury selection. I'm not sure exactly where we were yet. And before Ms. Cook joined, there was a recording with chit-chat between me and Mr. Richardson about witnesses in the case, about the state of the case, about why I was calling witnesses and not calling witnesses, and complaining about somebody who had Ms. Minton's credit card and was going over the limits, and chit-chatting as counsel do between themselves, waiting for a witness. And I don't think people understand the context of how attorneys talk to each other. I think that the witnesses who overheard this, Ms. Lucinda Cook and whoever else she communicated with, think that because this is a capital murder case, me and Mr. Richardson should be like this with our hands around each other's throats every moment. And we were not that way. We were chatting as counsel do in a case. And in a capital case especially, do counsel and adversaries have to communicate frequently and exhaustively to get the thing from start to finish done. That's all that it was. There is nothing in there that was inimical to Mr. Jose Soto-Escalera's defense, and I defy him or anyone else to point to any action or anything that I did or said at any point in the preparation of this case, or in the trial, or in the penalty phase that was contrary to his interest. It's nonsense and bull crap, and that's what he's on about, Judge. So he can feel however he wants. He's an idiot. On this issue, at least.
In that regard, for Mr. Soto-Escalera's benefit, the people who are here observing this proceeding, regardless of the court's sentencing decision, whether I impose a life sentence or a death sentence, there are appeals that take place directly and then indirect appeals, which relate to assistance of counsel, whether the defendant received proper assistance of counsel. That's for a different day. I could see this coming up perhaps in that scenario on the merits to be figured out at that time as appropriate, which goes back to what I said before. The evidence is in, mitigation has been placed before me, so we're at that stage where I'm to consider that. Put differently, if Mr. Soto-Escalera feels that Mr. Burns did not properly litigate his case for whatever reason, will be a proceeding in that regard. But to be fair to Mr. Burns' respected counsel before the court, usually what has to be shown, or what would have to be shown, is something of substance, not just some idle remark we see from criminal defendants all the time, like, my attorney is working for the state, because look, they're smiling at each other and they're acting as professionals and not constantly cursing and berating each other and putting each other down. That's not the expectation of the court. In fact, we foster the opposite as professionals, that they get along, because once this case is over, they'll be on to a next case, and so will I. And so as professionals, they have to work with each other. But more importantly, as I mentioned at the outset, that is for another day. I'm directly focused on the extremely consequential and important decision I have to make, which goes back to whether Mr. Soto-Escalera wants to make a statement regarding himself, the case, for me to consider. He does not have to, and it's not going to affect him negatively if he doesn't, but he has that right to do that. So there again, we broached a different subject. I don't want him to think that I'm not going to listen to that, should he wish to listen to make that statement. On the other hand, I'm not sure he has an intent to do that anyway. He just wanted to broach this subject.
Correct, Judge. I think he
Okay.
said his piece and he has nothing
Okay.
to say at this
All right,
point.
so it's not the first time I've had to tell the defendant or someone else, that's for another day. There is a right to have a motion for post-conviction relief with regard to your Sixth Amendment right to counsel. That's for another day, really regardless of my decision here. So other than that, that concludes the Spencer hearing evidence from the defense. Any evidence from the state before argument?
No evidence, sir.
All right, so let's start off with the argument of the state. If you wish to make a summary argument, but you don't have to. I mean, obviously, I'm familiar with my role here. I want to dissuade you from that, but you do both have the right to make argument to influence me in the way I evaluate the evidence,
Sure.
the way the aggravation and mitigation.
Yes, sir. I would just say that based on the extensive evidence that was adduced in the trial and the penalty phase, based on the aggravated factor findings of the jury, as well as the verdicts of the jury as a whole, the state requests that the court impose 2 death sentences in this case on both counts. Thank you.
Thank you. And the defense, Mr. Burns.
Yes, I do have a few comments to make, Judge, in the nature of argument, some of them addressing aggravators and some just in general. One of the things that needs to be considered and proved is that there was heightened premeditation in this case. I think certainly there was evidence that this case was planned and thought about at least for some days before the actual killing occurred. I don't know how extensive or how important the court would consider the testimony of the witness who indicated that Jose was interested in ghost guns, I think a couple of weeks before the killing. I don't know whether that manifests as an expression of an intent to do anything wrong. This was not a shooting or a gun crime. It did not arouse in the witness's mind at the time that there was anything nefarious going on. He thought that Jose might have been building a gun for sale. And so what we have here, the evidence in the case was that this was a pregnancy of many months' duration that Jose objected to from the start, and yet there was no evidence of any kind of intent to do anything wrong until only a few days before the actual event. And so I would ask the court to consider that. On this next issue, again, I don't like to tread here, but these are just unsavory matters to begin with. Regarding the aggravator of child under 12, I certainly do not dispute that that aggravator is correctly found. I do offer for the court's consideration that the manifestation of that aggravator in this case is as mild as could be. I don't want to state it any more bluntly than that, but what we lost here and what we mourn here in Josiah, we lose and mourn speculatively. There's no personality that has been evinced. And so I think that although that aggravator is properly found, it could be even more horrible. We have testimony from Raul Benasco relative to the court imposing a life sentence without the possibility of parole, which is what I'm asking for in regards to each victim. That Jose's been fined while he's been incarcerated for many years in a county jail, which is not designed for long-term incarceration. He would be a good prisoner. He has skills to offer. They work them hard in prison. Jose has skills to offer. I also want to ask the court to consider that the nature of persons who ought to be executed should be such that Jose doesn't really fit the category. He has no prior criminal history whatsoever. This is a dramatic departure from nothing to a very horrible crime, but it is a crime of personal circumstances. It is not a crime of randomness. It is not a crime against strangers. It is not a crime where Jose indicates that he is some kind of danger to the community at large. It is a very particularized type of crime, again, wildly at odds with his nature that we heard from his family and that we heard from Dr. Schwartz, and that is evidenced in his lack of a criminal record, which I think is really quite astounding. And finally, I think I would be remiss if I did not remind the court that although the recommendation is for death, it was as close a call as could be possible, and I would ask the court to consider that also in leaning towards life without possibility of parole for both counts. Thank you.
Thank you. Any response by the state?
No, sir.
In abundance of caution, let me ask a question to the state. And in part, this is just to avoid the appearance of us as with regard to the evidence that we glossed over anything. I have my own view of the evidence, and I'd certainly listen closely. I don't know that this was really fleshed out in argument before the jury, but with regard to the cold calculated, premeditated, aggravating factor, which was found by the jury beyond a reasonable doubt, is my perception of the evidence correct from the state's view in that it does appear that there was substantial planning fitting the definition? However, there was a variance between a lot of the planning and the actual way that the crime was committed, in the sense that there was a lot of talk of a gun, and then the murder occurred by different means, and which doesn't undo the aggravating factor, but it's something because I've never heard the state directly address that. I don't think the state directly addressed that with the jury, because it's kind of an aside, but just to cover every base, and because it was brought up by the defense, what is the state's view of the situation there with the evidence?
Yes, so the evidence, the way the evidence shook out was that there was a significant degree of planning in the days leading up to this, particularly beginning on August 21st of 2018. The defendant discussed using a firearm on multiple occasions, but the court is correct. At no time did the defendant ever discuss cutting her throat or hitting her in the head with a large blunt object, which was the ultimate cause of death in the case. So although there was much discussion, and I think he did go back and forth on the way he would kill her, I don't recall any specific statement regarding either cutting her throat or hitting her in the head with a large blunt object. He actually, and he also did discuss using a second person, presumably Eric Alvarado, but again, there's no evidence that that was actually carried out.
And there was discussion, I have this in my notes, but just in an abundance of caution, there was discussion between the defendant and Mr. Alvarado in the garbage truck about the location of where the crime would occur.
Yes.
The route, the garbage route.
Oh, yeah, in several different conversations that
Right.
occurred. Yes, sir.
All right. Well, particularly given what was brought up with regard to counsel and so forth. I do want to commend the attorneys for their fine work. And no one can do that better than me because it's right now squarely before me. Let me tell you where I am in the case. This is one of those situations where as a judge you could try to put the case out of your mind as much as possible. But I've found doing this that even when you think you're doing that, you're still thinking of this case. And I've been constantly thinking about it. I'm far along in my analytical process. However, more has been put before me today, particularly fleshing out other suggested mitigation and a few others that are also new suggested mitigation. So I have that to shore up, but I do intend to finalize my decision and announce my decision this Friday, which is the 10th at 1:30. There's a chance that I'm not done by then, but I think I will be done by then. There again, I'm far along, and I appreciate the doctor's report. I will review it in exquisite detail and dissect it along with my notes to make the final decision in this case. Either way, the decision of the court must be in writing. So I will announce the decision on Friday at 1:30, and we'll see you then.
Yes, sir.
Thank
Thank
you.
you, Your Honor.
Go off the record. Now, in the